up your shipping with customs. We also have our own fleet of delivery vehicles and deliver door to door. For more information, call 941-3261. Fax 941-3269 or email al-services@tciway.tc. At TC Crystal, you will find clean, pure water bottled right here in Provo. This water is purified through reverse osmosis and it's ozonized. We're also known for our good service. We're located in the industrial park next to Turk's Bear. Remember, if it's clear, it must be crystal.
Oh, Digicel it's a lot better. What Digicel has brought to Turks and Caicos, no one has ever seen it before, because they take very little from customers and give a whole lot back. And that is so exciting just to be a Digicel customer.
Digicel, brother. I don't know about anything else.
Digicel is great. It's good to be a Digicel customer.
You too can be a winner with Digicel, the bigger, better network.
Blue Notes News and Advertising Production Company is here in the Turks and Caicos to help you remember your precious moments. We produce weddings, funerals, birthdays, special moments, church events, you name it. Our track record speaks for itself on the quality. For more information, call us today at 649-331-6900 or email info@bluenotesinc.com. Welcome back to TCI Behind the Scenes, and for this part of the show, we're having a chat with Mr. Arthur Forbes from the Labor Tribunal. Hello, Mr. Forbes.
Good morning to you.
Now, I've just found out quite a bit about the Labor Department, and of course, whatever happens with labor and they're unable to resolve some matters, they can refer to the tribunal. So tell me, the tribunal has been around for about 4 years now?
Yes, we started 3rd of November 2004.
Right, and you all have seen so many cases and some novel resolutions, and one of those, of course, affected WIV, maybe more than one.
A few of them, no doubt.
And tell me, something I really wanted to find out about what is the main problem that comes to the tribunal?
The main problem that the tribunal faces at the moment is unfair dismissal, and that is a challenge in the sense that we have workers, or migrant workers, so to speak, that have been employed, laid off, and other migrant workers come in and do the same duties. While the migrant workers, the present migrant worker, if you like, they have valid work permits and labor clearance. The challenge for the tribunal is dealing with that unfair dismissal. It no doubt creates a human right issue in the sense that under the immigration laws, that persons, migrant workers, are not allowed to change employer without the consent or directive of the immigration board. And that seems to be a problem when it comes to bringing a matter before the tribunal and dealing with the matter fairly, expeditiously, and to, if you like, for the interest of all concerned.
The matter normally should start with labor, because in bringing in someone, you have to get the labor clearance. Now, if you're giving labor clearance for a particular position in a company, do you think they just automatically think that they're having two persons in this position, why they would grant two labor clearances? And of course, one is, as you say, has already been terminated?
Yes, or laid off. And most the cases that have reached the tribunal are cases where the migrant worker has been laid off for one reason or the other, and the law requires the person bringing in that migrant worker to actually put a cover letter, if you like, to the immigration board and to the the Commission of Labor stating why they want the person in and basically the duration of the employment. And so it's frustrating then, obviously, things happen where it's beyond person's control. For example, there may be a downturn in the economy, or there may be shortage of materials, especially on the construction industry, where you have the hospitality industry. You may have a slowdown. There are certain peak periods of tourists, so one could understand that. But then, when bringing someone from overseas, that should be taken into account.
Yep.
Now, and having said that, you should also, according to the immigration ordinance, do all that you can to make sure that you have tried to put, at least look for a belonger to fill that position. And, as I mentioned, it's frustrating for the tribunal to deal with matters fairly and expeditiously when you have migrant workers here who are unable to work, have a social problem because of the restrictions placed by immigration ordinance,
Yep.
and you have another person, a migrant worker, doing the same duties or carrying out the same duties. We have a few cases pending on that, so it'll be quite interesting to see the outcome of that.
I'll say. And it sounds like the tribunal here is quite a would you say, before I even jump to any conclusions, would you say that you have to sit more over migrant worker cases than locals?
At the moment, I think from our stats, it's about 60-40 in favor of, if you like, migrant workers.
Wow.
Yes. Well, one could understand most of the task force, if you like, our workforce,
Yes.
are migrant workers.
Yep. Oh boy. And recently, we've had great upturn in the tourism industry, and most of the hotels, even right now, are quite full. And employees are a bit upset over the fact that they figure that their pay packets would also be reflecting this. And a number of them are saying it's not. And has the tribunal been appraised of it?
Yes, we have had, in fact, we have about 2 cases before us right now as we speak, relating to service charges. And that is where workers are claiming that they were not paid the appropriate charges that is required by law. Now, under that, because the employment ordinance certainly gives the tribunal the powers to deal with any matter relating to employment, that service charge also falls under that. So the tribunal has the remit to deal with that. And under the service charge ordinance, it does state clearly that where a service charge is being levied, that their employees shall be paid not less than 60% of the service charge, and it should be shared equally among the employees. Now, who are the employees, if you like, whether it's in that specific area or the entire organization, that again is yet to be determined. Obviously, we'd have to look at case laws and deal with that when it reaches the tribunal, when we adjudicate on such matter.
I was about to ask. I mean, how do you determine, and how does the employee decide whether or how much they figure they should be paid? I mean, is it across the board, the entire workforce that gets a portion of the service charge, or what?
One of the things that is very interesting is that under the SAD ordinance, that's the service charges ordinance, the minister could actually draw up regulations or state how service charges are to be levied on that particular facility or hospitality organization. And otherwise, the tribunal has to look at case laws. And the good thing about it is that the employment ordinance allows the tribunal to refer something such as that, where there's a gray area. It may refer that to the Supreme Court for a decision on a matter of law. So, but before we do that, we exhaust all the avenues available to us, including case laws and the employment ordinance and the service charges ordinance. So we yet to look through those because we haven't had a chance, if you like, to properly hear all the parties' argument for and against those issues.
Are you saying that each property may have their own set of rules concerning service charge?
No, the law specifies that it should be not less than 60%.
Okay.
And payable after 21 days of each month, the 21st of each month.
Okay.
And shared equally among the employees. However, it goes on to state that the minister may, and that's the Minister of Finance, may make regulations or prescribe how those service charges are to be levied.
Okay.
Yeah.
So in a restaurant where there are only about 6 persons working, then they would expect to, of course, have more. And then in a hotel that has 400 to 900 employees.
Certainly. It'd be a bit less, perhaps.
Perhaps.
But depending on the amount of guests, obviously the amount of people that is being served and that charge being levied.
Okay. And it's equal to each person on the payroll?
That again, we have to look at the facts to actually assess that, because from the raw interpretation, or if you like, it just says shared equally among the employees. And that could be interpreted in many different ways.
Right, so the sweeper and the house cleaner and the executive, we all get the same, according to interpretation.
Well, that could be deemed that way, as you mentioned, but we have to then look at the arguments put forward by both parties and deal with it from that angle.
Okay. And presently, how many cases presently before the tribunal?
We have about, I would say, in the range of 20 cases before the tribunal. Many of them are ongoing, adjourned for some reason or the other, being that the president, who happened to be myself, is the only full-time employed person at the tribunal when it comes to adjudication. And we have 2 other part-time members who obviously have their own business or employed by someone else, which means that even though they may be working for the tribunal, they have a moral obligation or duty to serve the employer, or at least give them so much time out of the week.
Okay. Sounds like you still have your hands full with a lot of these cases and a lot of gray area.
Yes, the Supreme Court and the Court of Appeal has been very helpful in clarifying some of the gray areas. For example, when it comes to remuneration, the Court of Appeal just recently held that where an employee is owed wages or remuneration, there's not a time bar on trying to collect that money. And that was, it's unlike unfair dismissal, where it says you have 6 months to bring your complaint to the tribunal. Otherwise, unless you have reasonable grounds that it should be extended or you should be granted an extension, then it is statute barred.
No.
So that is a very clear ruling now, where someone is or believe he or she is being owed money that she or he is entitled to, then they have the right to pursue that beyond the 6 months time limit.
Okay. And for those who can't ask at the moment, how can they get more information?
Well, the tribunal office has a copy of the employment ordinance available that the public could see. And when they do, for the ordinary person, that's employer or employee, who have a complaint or an issue, the tribunal office will actually show them the relevant section relating to the issue and lots of cases give them copy of that particular section so they could see how the law applies to that particular issue. I must say the Department of Labor also have the same services available. And if one needs a copy of the employment ordinance, you could get that from the Attorney General Chambers. That's here on Providenciales, or the district commissioners in the various islands where you do not have the presence of the Attorney General Chambers, or in Grand Turk at the AG's chambers.
Okay.
And the tribunal urges the employers basically to adhere to the Section 62 of the employment ordinance when it comes to warnings, and Section 60 when it comes to summary dismissal, because there are very clear guidelines about that. That, for example, if an employee does something wrong, the employee is entitled to have some guidance of what they're doing wrong and how they need to correct that. And should the employer follow those procedures, the tribunal will have less cases coming to the tribunal. And obviously you'll have a better working relationships between the employer and the employee.
Thank you. Sounds like we all just need to get us a copy that we keep as a Bible, second Bible, of the labor ordinance. So go out and get yours today, of course. Right here in Provo, you come on down to the Labor Tribunal office or the Labor office and make sure that you're fully appraised of what's going on. Thanks for watching, and we'll keep you informed about what's going on behind the scenes.
This show is sponsored by Digicel. This program is also brought to you by Astrum International Limited, which offers a wealth of construction experience, expertise, and professional service, as well as providing comprehensive solutions in the fields of commercial and residential construction. Astrum International has been operating in the Caribbean for over 35 years and is currently building the 7 Stars Resort on Grace Bay Beach in Turks and Caicos.